What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta, owner of Rekieta Law, a small law firm in central Minnesota. If you're ever in Minnesota and run into legal issues, please give me a call, see what I can do for you. All right, so today is uncharacteristic of me. It is the second day after these documents dropped. I was stranded away from a computer yesterday and unable to record. So here I have them for you today. Many of you will have probably read these documents. They are not long, and so this video will not be overly long in respect to these documents. But what I hope to do is actually go through them very quickly. And then, as this is episode 30, the 30th video on the LoLsuit, I will try and give a recap and summary of the major events that have happened. Mainly because, look, I've been covering all these documents for a while. I know I live stream them. And sometimes those live streams get long, and some of the earlier live streams were pretty hectic. So people might not be aware of exactly what's going on. And, for those of you out there who are fretting over maybe missing some stuff from the live streams, don't worry about it. The reason we do them as live streams is to really just revel in what's going on. And kind of just hang out in that moment of wonder as we read whatever Landau has decided to come up with, because his arguments are so bad. They're bad. And the other arguments from the other lawyers, part of the comedy of that is trying to, find the moment where their sanity snaps, and they just can't comprehend what is actually occurring in their profession at the moment. But if you watch through to the end of this video, you should have a good grasp of where everything is, what major events have occurred, and kind of what the future looks like for this LoLsuit, at least as far as we can predict. So, bear with me, and we'll get through that tonight. Oh, I have a couple things to say. I got this lovely glass from My Room Records. Thanks a bunch, buddy. I really appreciate it. And I am going to christen this glass. It's the Glencairn glass, and it's been etched with my business logo, right? And I'm going to christen the stream with this glass. And we're going to have, we'll go with the Balmore. But I also want to point out that my buddy Guns Beer Freedom has also sent me some Heyman's Old Tom Gin, which I'm anxious to try. And then also, I sort of speak some French, but I don't know how to pronounce this. Larrasingle. It's an Armagnac. It's a brandy. Very good. I had a little bit of this earlier. It is wonderful. Very smooth. Kind of a mild, sweet taste. A little bit of orange to it. It's very good. I'm a fan. And I'm going to have the gin, but I'm not going to have the gin tonight. Tonight is a Scotch night. So, thanks for hanging out with me through that. But you gotta properly prepare yourself for some of this stuff. So, as a brief recap, if you are not familiar, so there, and I'll cover this more fully after this update, but there is currently there are three sanctions motions. One from Kevin Landau. He has made a motion for sanctions against Greenberger, who is Asterios' lawyer, and Munoz, who is the lawyer for Weber Shandwick. And then each of those two parties, Greenberger and Munoz, have filed cross motions for sanctions against Kevin Landau. When in the last live stream we covered both of those, or well, actually we covered Landau's reply to both of them, which was frankly embarrassing. That is good. It was frankly embarrassing, terribly ill-reasoned, poor legal arguments. It's actually a little bit sad at this point. So anyway, his defense against Munoz was the most baffling thing I may have seen, because here's what happened. So when Landau filed his sanctions motion against Munoz, he said that there would be, he set the date for the hearing as April 2nd. Okay, that was the Monday following Easter Sunday. And under the New York rules of civil procedure, the reply brief for a motion for sanctions is due 1 day prior to the hearing date. So I guess there's the potential question of what day that is if Easter Sunday is the day before the hearing date. But with e-filing, you could technically file that reply motion on Easter. You can get that into the court. But Munoz doesn't do that. Munoz actually files it prior to 4:30 p.m. on Friday. So during the business day before the hearing. Ignoring the fact that this is like 3 days before the hearing. So he files it that day. And Landau has the gall to go before the court and say that that filing is untimely because he filed it right before Passover. Landau is apparently Jewish. He filed it right before Passover. Okay. Buddy, you set the date as April 2nd. So someone filing something on the 30th of March is not a problem. But so anyway, I'm sure Munoz was not expecting a timeliness argument against his reply, considering his reply was within the time set by Kevin Landau. So he didn't anticipate the request to strike his response based on untimeliness. So it's not addressed in his motion, which was timely, or his response to the motion, which was timely served. However, as he is apparently a very thorough and good lawyer, even though the argument that it should be stricken is ridiculous, he filed this letter and a proposed reply, and he has asked the judge to allow him to file this reply. And so he files the letter is to the judge, and the proposed reply, and if the judge accepts the proposed reply, it'll be added to the record as of the filing date. So we're going to go through those two things real quick. And the proposed reply is merely addressing the timeliness issue. So first, let's go through the letter, because this is an interesting thing. Sometimes lawyers have to converse with judges outside of motion practice, right? And typically you have to do these things, and they have to be either filed or publicly available or made available to all the parties so that they know. So you're not speaking to the judge without the other party having a chance to have their say, so that, this gets sent to everybody just as a form of notice. But it doesn't mean that everybody has a right to say something about it. Landau could object to this letter if he wants, but, he'd have to have a good reason, and he doesn't. So this is kind of a different look at how things go. Oh, excuse me. We've had a long day. So anyway, here we go. Dear Judge Ramos, we represent defendants CMGRP Incorporated doing business as Weber Shandwick and Joshua Kaufman. In this action, plaintiffs filed a motion for sanctions against the undersigned counsel and the counsel for defendant Asterios Kokonos on March 14th. On March 30th, we opposed the motion and filed a cross motion. In reply papers filed on April 1st, 2018, plaintiffs argue that our opposition was not timely. So, just further compounding the irony of all this, he says that their motion's not timely, yet he's filing on Easter Sunday. So, a little bit weird. We respectfully request that pursuant to Rule 18 of the Rules of the Commercial Division, the court grant us permission to file the enclosed short SIR reply on the issue of timeliness only. Attached hereto is Exhibit 1. Plaintiffs contend that CPLR 2214B required that our opposition be filed 7 days before the motion's return date and request that the opposition be stricken as untimely. CPLR 2214B reads in pertinent part that, quote, answering affidavits and any notice of cross motion with supporting papers, if any, shall be served at least 7 days before such time, if a notice of motion served at least 16 days before such time so demands, emphasis added. Further, a notice of cross motion must be filed, quote, at least 3 days prior to the time at which the motion is noticed to be heard, or 7 days prior to the time if demand is properly made pursuant to subdivision B of 2214, and that's citing Rule 2215A. As set forth in the SIR reply, plaintiff's notice of motion does not, quote, so demand that answering affidavits or cross motions be served at least 7 days before the return date. In fact, the notice of motion states that pursuant to CPLR 2214B and 2013B, reply papers, if any, are to be served so as to be received by the undersigned at least 1 day prior to the return date of this cross motion. And then there is a footnote here. The notice of motion erroneously refers to plaintiff's motion as a cross motion and to the anticipated opposition as a reply, but the intent is clear. Because plaintiffs did not demand that the Weber defendants file answering affidavits or cross motions at least 7 days prior to the return date, the Weber defendants properly filed their opposition and cross motion 3 days prior to the return date. Plaintiffs further object to the fact that the Weber cross motion coincided with the Passover and Easter weekend. Plaintiffs' argument is nonsensical, as plaintiffs themselves set the motion schedule, including by setting the return date as the Monday following the holidays. We note that plaintiffs also filed a reply to a separate cross motion yesterday, that was Easter Sunday, without any apparent holiday interference. Finally, if plaintiff counsel had a conflict with the briefing schedule, which he set, plaintiff's counsel should have simply reached out to me to discuss an extension. As noted in our cross motion, plaintiffs filed their opposition to the Weber defendant's motion to dismiss 13 days after that opposition was due. As a professional courtesy, I reached out to counsel to discuss his late filing before approaching the court. I offered not to object to the filing as long as plaintiffs consented to additional time for the Weber defendant's reply, which plaintiffs' counsel accepted. I received no such courtesy in this instance. Plaintiffs' objection on this issue of timeliness, therefore, further demonstrates a pattern of conduct by plaintiffs that is not only discourteous, but frivolous and a waste of judicial time and resources. For the reasons discussed herein and in the proposed SIR reply, the Weber defendants timely filed their opposition and cross motion, and those papers should be considered by this court. The Weber defendants respectfully request that the court permit them to file the SIR reply to address these issues. There we go. Now, let's look at their SIR reply. This is only a couple pages long as well. So, proposed SIR reply memorandum of law in further support of defendant CMGRP doing business as Weber Shandwick and Joshua Kaufman's opposition to plaintiff's motion for sanctions, and in further support of their cross motion for sanctions against plaintiffs and their counsel. Defendant CMGRP Incorporated doing business as Weber Shandwick and Joshua Kaufman respectfully submit the SIR reply memorandum of law in further support of their opposition to plaintiff's motion for sanctions and cross motion for sanctions against plaintiffs and plaintiffs' counsel. Argument. Plaintiffs filed a motion for sanctions against the undersigned counsel and counsel for defendant Asterios Kokonos on March 14, 2018. On March 13, 2018, the Weber defendants proposed the motion and filed a cross motion. In reply papers filed on March 1, 2018, plaintiffs argued that our opposition was not timely. Plaintiffs contend that CPLR 2214B required that the Weber defendant's opposition be filed 7 days before the motion return date and requests that the opposition be stricken as untimely. It reads in pertinent part that answering affidavits and any notice of cross motion with supporting papers, if any, shall be served at least 7 days before such time, if a notice of motion served at least 16 days before such time so demands. Further, a notice of cross motion must be filed, quote, at least 3 days prior to the time at which the motion is noticed to be heard, or 7 days prior to such time if demand is properly made pursuant to subdivision B. Plaintiff's notice of motion does not so demand that answering affidavits or cross motions be served at least 7 days before the return date. In fact, the notice of motion states that pursuant to CPLR 2214B and 2013B, reply papers, if any, are to be served so as to be received by the undersigned at least 1 day prior to the return date of this cross motion. Because plaintiffs did not demand that the Weber defendants file answering affidavits or cross motions at least 7 days prior to the return date, the Weber defendants properly filed their opposition and cross motion 3 days prior to the return date. Plaintiffs' objection on the issue of timeliness further demonstrates a pattern of conduct by plaintiffs that is not only discourteous, but frivolous and a waste of judicial time and resources. For the reasons discussed herein, the Weber defendants timely filed their opposition and cross motion. Those papers should be considered by this court. That's it. This is not a big update. This is a very small filing over a petty timeliness issue. A non-issue, I should say, because their argument is correct. No one thought that their argument was not time, or that their opposition and cross motion were not timely filed. They absolutely were. Just a moment. Like I said, it's embarrassing, okay, to have this Kevin Landau guy come out here and just be such an unbridled idiot is embarrassing. But let's take a quick moment to recap let's take a moment to recap, I guess, what's going on in this case. So, from the beginning, Dick Masterson and Maddox were former co-hosts of a podcast called The Biggest Problem in the Universe. There is an ongoing trademark dispute about the ownership of that podcast, of the trademark related to that podcast, I should say, between these same two parties. And I have done videos on those. They are called The Biggest Trademark in the Universe. You can find them on my channel. If you are interested, please check them out. That started before this lawsuit started, and it is currently on hold awaiting a ruling on summary judgment. So we'll see, hopefully, that ruling comes soon. Maddox has sued Dick Masterson for $20 million, among a few other people, including Asterios Kokonos, a guy named Greg Bozer, I believe a gentleman named Lauren Baker, Dick Masterson's the company that he helped co-found, which is a media company called Foundation Digital. They have also sued Weber Shandwick, which is Asterios Kokonos' employer, along with Joshua Kaufman, who is the general counsel for Weber Shandwick. It is important to note that he is being sued as an individual, not in his capacity as general counsel. They have also sued Patreon. And speaking of Patreon, you can check out my Patreon at patreon.com/lawsplaining. But they're also suing Patreon and the Patreon creator representative by the name of Jordan Cope, who is basically a customer service phone and email rep for Patreon, from what we gather from the documents. He is also being sued in his personal, not professional capacity. Finally, they have also sued Trevor Burt, the creator and actor behind the Mad Cucks parody of Maddox. At this point, it's important to note that both Lauren Baker and Trevor Burt were never served in the case. They were not served within the 120-day time limit, and the case is, for all intents and purposes, dropped as regarding those two individuals. So, what we are left with are 4 teams of individuals that are represented by counsel. You have Asterios Kokonos, who is represented by Jordan Greenberger. You have Weber Shandwick, Asterios' employer, and Joshua Kaufman, who are represented by Michael Munoz from Golenbach, Eisman, Asserbell, and Pesco, LLP. You have Dick Masterson, Greg Bozer and Foundation Digital being represented by Edelman Matz, primarily represented by Sarah Matz of Edelman Matz. And you have Patreon and Jordan Cope, and their attorneys' names frankly elude me at this moment because their attorneys are not very funny. They're very straight-laced and dry, and they seem to be very thorough, but they're not hilarious. Greenberger is by far the funniest attorney that we've got going in this lawsuit. Maddox is represented by, Maddox and Jessica Irene Blum. Maddox's beautiful African-American girlfriend, who is involved in all this as well. Important to note, the girlfriend that has a restraining order upon her for harassing and stalking Dick Masterson's girlfriend, who shall not be named in this video. But yes, she has an actual restraining order against her for actually doing the things that Maddox is accusing other people of doing. So there's that. They are represented by Kevin Landau of the Landau Group, who has turned out to be the second funniest, or I mean, I guess it depends on how you measure it, the funniest attorney I've ever encountered. He is an absolute train wreck, at least in this case. Appears to be a train wreck in other cases as well, but this one is particularly bad. So, Maddox filed his complaint about all of the parties, and each of those four defendants and defendant teams have filed motions to dismiss for various reasons. Dick Masterson's motion to dismiss, for example, was one for improper jurisdiction because Dick Masterson has no business ties to New York that are related to this lawsuit, and he should probably have been sued in California. So the jurisdictional claim is there. It's also an inconvenient forum, so even if they decide that New York is a proper jurisdiction, they might decide that the forum of New York is inconvenient for all the parties, and therefore they would remove it to a California court to apply New York law. That sometimes happens. That would be really weird, but it is an inconvenient forum, as all of the parties and basically all of the evidence are in Los Angeles, not New York. And finally, the most important dismissal request is for failure to state a claim on which the court can grant relief. Basically saying, yeah, even if everything Maddox says in his complaint is true, which it obviously is not, and we'll get to that in a little bit, but even if it were all true, it's not illegal. It's not, it doesn't infringe upon any right that he has, and the case should be dismissed. So, aside from that, Asterios has filed a similar request to dismiss based on a failure to state a claim. However, he could not use a jurisdictional argument because obviously Asterios is in New York and is in the forum state, so they do have jurisdiction over him. Weber Shandwick, roughly the same thing, failure to state a claim, and have pointed out numerous defects in Kevin Landau's legal reasoning. And finally, Patreon has asserted that New York does not have jurisdiction over Patreon. The forum is not convenient. Further, that Maddox has violated their terms of use because when he filled out their terms of use, he agreed to hear anything in a California court, specifically in San Francisco. And further, he agreed to binding arbitration prior to any legal action taking place. So the court should dismiss because he should be arbitrating this according to the terms of use of patreon.com. And even if the arbitration is not upheld by the court, the choice of venue, choice of forum provision in the contract or in the terms of use stands either way, and this should be held in San Francisco. And finally, they have also dismissed for failure to state a claim because everybody dismisses for failure to state a claim. It's a very common dismissal request in civil litigation because if you win it, you win. And in this case, all four people should win because nothing that anyone did here was illegal, to be very clear on that. So all of those things have happened. Events that have happened in the meanwhile. Landau filed a frivolous motion against Asterios Kokkinos. When he thought that Asterios did not timely file his answer, they filed for default judgment. A default judgment is when you fail to answer in the proper amount of time. The court says you win automatically because the other person failed to answer. The problem was Landau can't count. And Asterios still had another 12 or 13 days to answer at the time that the motion for default judgment was put down. And then that was taken care of, presumably by Greenberger behind the scenes, and Kevin Landau withdrew the motion. Yeah. So there's how that went. Then later, Dick Masterson received some documents and had been talking about Kevin Landau, and then Kevin Landau filed a motion for sanctions and an injunction against Dick Masterson and literally the entire internet from stating the name Maddox or from saying anything negative about Kevin Landau, like the fact that he has so many drunk driving incidents that his license is permanently suspended and he is no longer allowed to drive. And also, they didn't want people, like reading transcripts in court talking about just how he failed a rolling interlock ignition test on the first day that he got it. On the literal first day that his interlock was installed on his car, he failed the test, presumably due to asthma and and drinking Listerine to help with the gingivitis caused from using his inhaler. Right. So, the court didn't agree with that either, because I know you're sighing on the inside. But, yeah, so Landau didn't want anyone talking about that, so he filed a motion against Dick for sanctions and an injunction for his speaking against that. But it also bound literally anyone who they would identify as a fan of Dick Masterson's, whether or not they are a fan of Dick Masterson, from saying the word Maddox online. And from saying things like Maddox is a giant cuck. They don't want people saying Maddox is a giant cuck. So he eventually withdrew the motion. We don't actually know why the motion was withdrawn. Presumably there was an agreement that Dick would not talk about certain things or not bring up certain things. And we know that Dick removed one of the bonus episodes that had been recorded that was about Kevin Landau. So I think it's safe to assume that there was some sort of agreement by Dick to stop talking about Landau, and that Landau withdrew the motion in regards to that, or in agreement with that. You know what I'm saying? So anyway, then we get into these motions to dismiss, and in the back and forth, this is where the real bombshell came out. On March 8th, I believe it was, Maddox filed an affidavit in which he admitted to being Heather. Heather is an individual named in the initial complaint, identified as an individual, not identified as one of the plaintiffs, but identified as an individual named Heather who sent emails to Weber Shandwick, which is Asterios' employer, to inform them of certain activities that Asterios was doing online. They were trying to get Asterios fired. Like, let's be real about what the intent was. And Heather claimed to be a journalist working for Condé Nast Media Group, and claimed to be writing an article about online harassment and cyberbullying. All of that was a lie, and turns out that Heather S. was actually Maddox, as admitted to in a March 8th affidavit. The problem with this is that was Maddox admitting to perjury and potentially criminal impersonation in the second degree in New York. Criminal impersonation in the second degree is where you impersonate a person without their permission. Actually, I don't know if their permission matters at all. You impersonate one person with the intent to cause harm to another person. And so Maddox has impersonated this person named Heather S. There is a Heather S. that works at Condé Nast. So Maddox is potentially guilty under that subsection. And the attempted harm would be to cause some sort of negative reaction from Asterios' employer towards Asterios, okay? The second part of that subsection, because basically Landau says that Heather S. is not a specific person, even though there is a Heather S. who works at Condé Nast. So there actually is a person, and you can find her LinkedIn profile if you look. Do not contact her. She has nothing to do with any of this as far as anyone can tell, of course. But and don't contact any of these people unless it's you just going on Twitter and saying Maddox is a cuck, because that's funny. Anyway, the second section of criminal impersonation in the second degree states that if you are pretending to be a representative of an organization with an intent to cause harm to another person, you're also guilty of criminal impersonation in the second degree. So by representing himself as a journalist from Condé Nast, even going so far as to state a specific article that they were working on in regards to cyberbullying and harassment in an attempt to get damage, to cause damage to Asterios Kokkinos, is an admission of criminal impersonation in the second degree. Now, does this mean Maddox will be charged in New York for these crimes? No, it absolutely does not mean that. It doesn't mean he won't be charged either. He very well could be, but there's a lot that goes into charging someone for a crime. A prosecutor has to basically review all of the information they have and decide if it's worth the prosecution, if they think they can win and get a conviction. In this case, it should be slam dunk. He is admitted to these events under sworn affidavits. So, but it still depends on whether the prosecutor thinks it's worth it, whether they have time to pursue it, and whether they think that it will produce a conviction. So, that is the state of the bombshell. Once this bombshell was revealed, Jordan Greenberger sent a letter to Kevin Landau. That letter contained a request that Kevin Landau notify the court, because that is a professional responsibility, duty of lawyers. When they find out that there is a falsehood that has happened, a false piece of testimony made under oath, they have an obligation to report it to the court to get that remedied as soon as possible. That does not mean dismiss the case necessarily. It doesn't mean anything. It just means that they have to tell the court what happened and maybe talk about why that happened or how it was coming about now. So Greenberger gave Landau 5 days to go ahead and do that. The next day, Munoz sends a letter to Landau. And I should say that Greenberger sent the letter to Landau and everybody else. And then Munoz sent the letter to Landau and everybody else, stating basically the same thing, that they believe that Munoz had an ethical obligation to inform the court of the falsehood. And if he did not do that, then Munoz would be forced to inform the court of the falsehood. And again, gave him time to respond. That was immediately replied to, immediate in the legal sense. So 2 hours later, it was replied to by Kevin Landau with a with a hissy fit of a letter directed at both Greenberger and Munoz, calling them unprofessional and a bunch of other names, and suggesting that they were in violation of professional responsibility rules and doing an ethical violation. And he actually filed for sanctions in court that same day. Despite giving them 24 hours to redact their statements, he filed for sanctions against them in less than 24 hours. Not that they would have redacted in that 24-hour period. Absolutely not, nor should they have done so. But he did file for sanctions against them in the amount of $10,000 in sanctions and $7,500 in attorney's fees. So, obviously, Greenberger and Munoz do not believe they did anything wrong. Pro tip, they did not do anything wrong. And they filed opposition motions, and here we are. So what comes next in this lawsuit? Well, on the 9th of April, the parties to the sanction motions must turn in physical copies to the judge. After that, I believe the next hearing is sometime in May 15th or 16th, potentially. There may be an earlier one as well. Let me see if I can look it up real quick while I'm just kind of gabbing here. But I have an image of it somewhere. But here we go. You guys won't be able to see this, but I'll tell you what's going on. Okay, so April 9th is the adjournment date for the working copies for the sanctions motion. Okay, so that just means that all of the physical copies of all of those documents have to be turned in by April 9th. If you don't turn in your physical documents to a judge who requires working copies, that's very bad. So that means that Greenberger and Munoz and Landau will all deliver physical copies of all of the documents that they filed in regards to this motion. So then, on the 14th of May, there is oral argument on motion sequence number 3. Motion sequence number 3, I believe, is Asterios' motion to dismiss. Let me verify that real quick. Motion sequence number... Motion sequence number 3, is Patreon. Patreon's motion to dismiss. So Patreon's motion to dismiss is scheduled for oral argument on the 14th of May. It's important to know that there is oral argument scheduled in this already, and it was delayed. So we'll see what happens. So then motion sequence number 4 and number 1 and number 2 are all scheduled for the 16th of May, 2 days later at 11 a.m. So that is the motion to dismiss from Dick, from Asterios, and from Weber Shandwick. So we will sometime in mid-May get some hearings, hopefully occurring. They're supposed to. Whether or not they will is an open question. The courts change schedules on things all the time, so it's hard to say whether this will happen or not. But we don't know what would happen in between now and then. I anticipate very little activity, but it's possible I will be shown wrong. Landau may have a fit over this letter being filed and the proposed surreply with the court, and he may file something in the next couple days against that. I figured we would probably see something today if that was going to happen, but it's hard to say. He might take a day or two to deal with that. So right now we're basically in a holding pattern, so there's not going to be a ton of activity that's predictable at this point. Anything can happen before then. People can file for sanctions. People can file for all sorts of stuff. Improper behavior can occur, but we won't know anything until May unless something out of the ordinary happens. So the best way to find out what's going to happen is to subscribe to my channel, watch for any sort of announcements, which means click the subscribe button, but there's a little bell next to it. If you click that bell, you'll be notified when my videos drop. So if you want to see what's going to happen, I tend to do a live stream or video the day that the document drops with a full analysis of everything that's gone on. So if you want to stay abreast of the situation, go ahead and click that subscribe and notify button so that you can follow along. You can also follow on Facebook and Twitter. And on Facebook and Twitter, I make the announcements in the Dick Show Facebook group. I make the announcements on the Dick Show Reddit page. And then I further make announcements on Twitter when there's going to be a live stream. And then once a video is released, like the end of this video, there will be a tweet that goes out that says that the video has been uploaded. So that's how you can follow along with this case. Otherwise, if you go to lawsuit.com, you'll be taken to the New York court webpage for this case in particular, and you can find all of the paperwork if you want to review it. You can also find, you can look for updates there. If you're a Patreon of mine already, at $5 or higher in the Discord channel, we do have a live bot that, a live bot? I don't know if that's a thing. We have a bot that monitors that channel as well, or that web page as well. And once new documents drop, the bot does update the page and let everyone know that documents have been released in this lawsuit. So that is where we are for the moment. In a holding pattern, anxiously awaiting the next bit of drama to come out of this. But, you know, that's it. So I hope this update has been helpful. If you get a chance, go back and watch the live streams. We have a lot of fun. I've changed the format. If you saw some of the earlier live streams and you weren't a big fan of how chaotic they were, I've changed the format on the live streams where the document reviews happen up front. Usually there's a couple minutes of introduction for me to kind of set the tone of the live stream, but we plow through the documents right away, and I only address Super Chat users, and I don't address regular comments until the end of the document. So it cuts down a lot on the chaos, and it allows us to get through the documents much more quickly. So if you watched early live streams and then haven't watched later ones, it might be worth checking them out if the chaos was kind of annoying you, and I understand if it was. If you see something that's like a 3-hour live stream, the documents probably take up an hour to an hour and a half of that. And then there's just shenanigans that happen afterwards because we're all having a good time with the chat, and all sorts of non-pertinent stuff comes up afterwards. So if you want to just check out the first bit and get the document information from any of the live streams, you can do that. And I've changed the format for you so that is more accessible. Otherwise, you can check out the podcast if you don't want to watch the video. That is on Google Play and Apple. If you search for lawsplaining or Rekieta Law, you should be able to find them. You can subscribe to that if you want. Otherwise, you can go on SoundCloud and find me directly at Rekieta Law on SoundCloud. These links are in the description of the video, of this video. So if you want an easy way to find them, you can go to SoundCloud and listen to any of the audio for any of my videos is released on there as well. And it's all free. You don't have to pay anything for any of this stuff. So go on SoundCloud. Lastly, if you want to support me on Patreon, you absolutely can, and you can get an easy access to the RSS audio that is uploaded there. There is bonus content, not specifically related to the LoLsuit, of course, but there is bonus content depending on what tier of patron you are. We do lots of live chats, weekly live chats, and we do, there's some other benefits as well. But I hope that has been a helpful update for people. If you have questions, please drop them in the comment section. I'm happy to answer questions in the comment section. Hit me up on Facebook or Twitter or really anywhere. Hit me up with a message on Patreon. It doesn't matter. Let me know. Reddit, the same. I get around to checking all of these things when I can, but I'm happy to answer questions or address concerns. So if you're confused about something, or if you have a question about a specific part of this LoLsuit, shoot me a message somewhere and I'll get your question answered for you. Anyway, I'm going to end this video. Thank you so much for watching. It is the 30th episode. I thought about doing something with a lot of pomp and fanfare and everything like that, but I think it's better to just do an update that is not ridiculously long. It is, 45 minutes is getting it's a bit much of a stretch, but I apologize for that. But it just takes time to tell these stories. So thank you very much for watching. 30 episodes in. Hopefully, for the sake of everyone involved, we don't have too many episodes left of this particular case, and we'll be able to say the case was dismissed because all of the claims are just absolute nonsense, and that would be great. But no matter what the outcome is, if the case is dismissed and it ends, you'll find coverage for that on this channel. If the case goes on, we'll continue covering it. So stick around and enjoy. I hope you have a good night. Find some whiskey, share it with a loved one. Peace.